Good evening, everyone. Welcome to the Rockefeller Center's first public program of the winter term. My name is Jennifer Lee, and I am co-president of Dartmouth Women in Law and Politics. And on behalf of our organization, I would like to thank the Rockefeller Center and the Dartmouth Minority Pre-Law Association for their support in organizing this event. Today, we are excited to host Dean Kimberly Mutcherson and Professor Mary Ziegler, who will be discussing the future of reproductive justice and abortion rights in the US. Before we get started, I have a few Zoom details to remind everyone of. Please ask your questions at any time by using the Q&A button. Asking your questions early will increase the likelihood that they will get answered. And to access Zoom's closed captioning feature, please navigate to Live Transcript and select Show Subtitle. If you don't see that option, look under the More button. Lastly, when you leave the webinar, you will see a survey. It is a big help to the Rockefeller Center if you can take the time to answer those 3 short questions in that survey. It is now my great pleasure to introduce our moderator for the evening, Institute for Writing and Rhetoric Professor Julie Kalish.
Hi, and thank you. And I wanted to thank everybody here for coming and joining us. It's cold out, at least it is up here, and everybody has a lot going on, and I really appreciate everybody coming. And thank you to the Rockefeller Center, and especially to Dartmouth Women in Law and Politics, and to our 2 speakers. That's my role to introduce, Dean Kimberly Mutcherson. She is the co-dean and professor of law at Rutgers Law School. She is a reproductive justice scholar, and her work sits at the intersection of bioethics, health law, and family, focusing particularly on assisted reproduction, abortion, disability, and medical decision-making for pregnant women and children. Her book, Feminist Judgments, Reproductive Justice Rewritten, was published by Cambridge University Press in 2020. She has held visiting positions at Columbia Law School and University of Pennsylvania, and has received awards for her teaching and scholarship and innovation. Most recently, she was the inaugural winner, if I can say that properly, of the American Association for Law Schools Impact Award for co-founding the Law Dean's Anti-Racist Clearinghouse Project. I like to mention these sorts of things for students who are wondering how people wind up in the careers that they're in. But before becoming a professor and a dean, Dean Mutcherson was a consulting attorney at the Center for Reproductive Law and Policy, which is now called the Center for Reproductive Rights, as well as a staff attorney at the HIV Law Project. Our other speaker this evening is Mary Ziegler. She is the Stearns Weaver Miller Professor at Florida State University College of Law. She specializes in the legal history of reproduction, the family, sexuality, and the Constitution. She has written extensively about abortion law in the United States, her most recently published book being Abortion and the Law in America, A Legal History, Roe v. Wade to the Present, which I think is very relevant to the topic this evening. This summer, Yale University Press will be putting out her book entitled Dollars for Life, the Anti-Abortion Movement and the Fall of the Republican Establishment. And she also has a forthcoming book called Reproduction and the Constitution that's scheduled to come out in 2023. She has also, her writing has been published extensively in journals, and she has also appeared in many media outlets ranging the full political spectrum from Fox to MSNBC and everything in between. She is currently on the board of the American Society for Legal History and has chaired legal history committees for the American Bar Association and American Association of Law Schools. She is also this spring a visiting faculty member at Harvard. So if anyone wants to hop on the Dartmouth coach and take a ride down to Harvard, she will be there. So we have a lot of people who have come this evening, which is great. And so we think we all met prior and agreed that we would love to spend as much time as we can on your questions and answers. This is a very sort of stressful time for many people, and a time where people have a lot of questions, and so we want to accommodate that as much as we can. Since the talk is titled Reproductive Justice in the US Law, I thought it might actually be helpful to start with the US law part. And Professor Ziegler, you literally wrote the book. on the legal history from the Roe to the present. Can you just explain for us where are we right now legally? What's the law right now, and how are we expecting that to change?
Yeah, so the law right now is that there's still a right to choose abortion until viability. And viability is the point at which survival is sort of plausible outside of the womb. It varies, of course, depending on the pregnancy and the hospital and the resources available, but somewhere between 21 and 24 weeks. And of course, then there's the reality on the ground, which is that access in large part depends on where you live and as well as on who you are, right? So if you're a low-income person of color living in Alabama, your ability to exercise your right to choose abortion is completely different than it would be, in Los Angeles, for example. But legally, at the moment, the rule is still that states can restrict abortion before viability, but only if they do so in a way that's not considered unduly burdensome. And unduly burdensome is shorthand for rules that have the purpose or effect of creating a substantial obstacle for folks seeking abortions. And so courts have been using that standard to invalidate some, but not all abortion restrictions. So it's a little bit of a magic 8-ball approach, right? If you pass a law now, if you're a state, you are not going to be sure about how a court is going to evaluate that law until the law is viewed by a district court, an intermediate appellate court, and potentially ultimately by the US Supreme Court. But part of the reason I imagine that we're here is that most of us expect that reality to change in short order because the Supreme Court has agreed to hear a case out of Mississippi called Dobbs versus Jackson Women's Health Organization. Dobbs involves a ban on abortion at 15 weeks. Now, obviously 15 weeks is before viability, right? Even at the early end of things, viability is well after 15 weeks. And the Supreme Court, since not everyone in the audience is a lawyer, has the discretion to hear cases, right? So there was nothing obliging the Supreme Court to pick this particular case. There was no disagreement among the lower court or within the lower courts about this kind of law. So this felt very much like the US Supreme Court reaching out to pick this particular case. The Supreme Court, of course, has a conservative supermajority. That's to say there's 6 justices. So even if one of the court's members who's not been nominated by a conservative president who's pledged to see Roe overturned, even if one of those justices were, for example, to have second thoughts about reversing Roe, there's quite literally an insurance policy in the form of other justices present to vote to overturn Roe in any case. So in order to side with Mississippi and Dobbs and uphold this law, the court would either have to say that the viability line doesn't make sense, right? And that maybe states can ban abortion at 15 weeks or 6 weeks or 10 weeks or 12 weeks, or the court has to say Mississippi's law is fine because there's quite simply no right to choose abortion at all. Going into early December, most court watchers, I think, believed that the court was certainly going to reverse Roe, but maybe in a kind of multi-step process. Maybe they would kind of use the Dobbs case to tee up something in 2023 or 2024. But it looks, based on what we heard at the oral argument, that the court is going to reverse Roe entirely, probably this summer. So by the end of June 2022, and probably repudiate the very idea of an abortion, right? Which means that we're going to go from what we already have, which is a patchwork with large stretches of the South and the Midwest having very little access to abortion. But those differences are going to sharpen dramatically. We expect somewhere between 20 to 25 states to be criminalizing abortion, almost all abortions immediately. There are going to be abortion battleground states where that number will probably grow in places like Florida, where my university is based. We're going to see a lot of unanswered and complicated legal questions, like what happens if you live in Alabama and you travel to New Hampshire to get an abortion, and New Hampshire says that abortion was okay and Alabama says it wasn't. Whose law gets to apply? Who gets to decide? There are going to be a lot of complicated questions. So I think post-Roe America will be a complicated and probably depressing place, but there will certainly be a place where the legal and political battles about abortion and reproductive justice are just beginning.
Can I add one thing? In lots of ways, as I'm gonna try to be professional and call you professor, but
you because call
Mary,
me Mary,
okay, because
we're
know
friends,
each other,
so this is not
very
gonna
hard
work
for me just to flip that switch. The truth of the matter is that we've really been living in a post-Roe America for a while. right? So what Mary described as the landscape of abortion law in the United States is not what Roe versus Wade said in 1973, right? So Roe in 1973 was much more protective of a right to terminate a pregnancy. First trimester, you can't regulate at all. Second trimester, you can regulate, but you can regulate for the health of the pregnant woman. And then third trimester, you can ban if you so choose, but there has to be an exception for the life or health of the pregnant person. All of that changed in 1992 with Planned Parenthood versus Casey, and that's what we've been living under since 92. And so there's been this, process of just chipping away at Roe for many, many years. And so when Mary says that a lot of us were expecting, just another chip, there is this level at which I think a number of us have been sort of taken aback by how quickly the landscape has changed and how aggressively the landscape has changed because of a few different justices sitting on the Supreme Court.
Yeah, so both of you already started to talk about what I was going to ask kind of in my next question is that, we have already in many ways been living in a post-Roe kind of universe. And as Professor Ziegler mentioned, there's a difference between the constitutional right to abortion and access to abortion. And there have been many states all across the country where abortion access is easier, and many states across the country where abortion access is significantly more difficult. And so there's this question of all right, well, at one level, like if we throw it back to the states, how much really pragmatically, practically is going to shift there. Professor Ziegler already started kind of talking about that. And to integrate a question that we got already in the Q&A, which is great because it was one of the questions I wanted to ask too, is like, well, so let's say you're living in a state that has criminalized abortion. What is that actually going to look like? Who's actually getting arrested? Is it the provider? Is it the person seeking abortion? Is it, we have the law from Texas of like, is it the friend who drove you to the clinic? Is it like, what are the different possibilities of, what this is going to look like? And either one of you can jump in since you both were already.
Yeah, I mean, I have a little bit of insight because I'm a historian. So I've spoken to some anti-abortion activists and legislatures about what they want to do. So I can tell you, I don't know what they're going to do, and they don't all agree on what they want to do. But I mean, so first of all, the what could be different or how much is going to change. I think one thing that's likely to change is instead of it being, there's one clinic in a state, there may be no clinics in a region, right? I mean, I think we're quite possibly looking at people needing to get on an airplane, right? I mean, I think you're going to see the entire South and almost the entire Midwest, and potentially eventually the entire South and Midwest having no abortion clinics at all. In terms of who gets punished, it's complicated, right? So in the pre-Roe era, historically, you would look at it and say, pregnant people are not going to get punished because historically they were punished only indirectly, right? They were shamed, they were exposed, they were forced to testify. It was a traumatic experience, but they weren't quite literally going to prison. At least if you're looking at sort of 19th, early 20th century, that's generally what you were seeing. Although there were exceptions for when you're looking at people of color who are being punished for conduct during pregnancy, they weren't quite literally being punished for abortion. That tended to be doctors, and it tended to be the quote unquote accomplices. So a lot of partners, a lot of people bringing people to clinics were the ones being punished. And there's some reason to expect that to continue, quite simply because states have been pledging since at least 2019, hey, we're not going to punish pregnant people. Like pregnant people are victims of abortionists, they would say, right? We're not going to victimize them again. I'm not really sold on that. I mean, one, because the people I've been talking to have said, well, maybe the pregnant people just need a little bit of education that abortion is wrong, but after a little bit of time, they really need to get with the program. And if they don't, they should go to jail too. And more importantly, I think practically they're going to need to, right? Because one simple fact, which is just self-managed abortion, right? We live in a world where people are going to have access to abortion pills. And they're going to be getting those pills quite often in the mail or from out of state. Now, is New Hampshire or California going to send the doctor or whoever prescribing the pills to face prosecution in Alabama? No, right? But who is going to be available to face prosecution in Alabama is the pregnant person who still lives in Alabama and has family in Alabama and has a job in Alabama and whatever. So I think states are ultimately going to be in a position where the options are going to be punish no one and create functionally a gaping loophole in your criminal abortion prohibition, or punish the pregnant person who's managing their own abortion. And it seems pretty clear to me that option B is going to be the one that will be taken. And I'm sure Dean Mutcherson will get into this more, but there's already a tradition of punishing particularly people of color for conduct during pregnancy already. So, and it's not, like a distant tradition. This is something that's been happening recently. And so I think both kind of logistical reality and recent precedent would suggest that we're going to see that too. Although I certainly think that it won't be limited to that. I think it'll be any medical provider who's still willing to perform abortions, with a caveat being that some states may define abortion quite expansively to include maybe, emergency contraceptives, other things like IUDs, and people who are considered accomplices. So I think it'll be that entire universe of folks who may be subject to criminal punishment.
Yeah, and I do really want to drill down on the point that Mary was making about sort of the landscape that we're already living in, which is, we've seen women be prosecuted for miscarriages or for, failure to manage their miscarriages appropriately, or we've seen women be prosecuted because they tried to self-abort, right? So that's not shocking. That's not a thing to think that that's really far off, that could happen and will happen in a world where the US Supreme Court has said, all right, it's hands off for us, and we're just sending it back to the states to individually make decisions about whether, when, and how somebody can decide that they no longer want to be pregnant. The other thing I want to say, and Mary also started to say this a little bit, but I think that this is really critical. Don't think that this is just going to stop at abortion, right? I mean, abortion is sort of a gateway to, access to contraception, to, a whole range of ways in which the state, given the opportunity, or some states, given the opportunity, want to control the reproductive lives of people, particularly of women, and particularly of people who states have traditionally thought either shouldn't have access to pregnancy and parenting, or on the other side of that, people who they are concerned are failing to have the kinds of babies that we should be having, right? So in a world where we are watching literally the complexion of this country change, that's scary to a lot of people. And so the idea of making sure that certain women have to carry their pregnancies to term, and particularly white women have to carry their pregnancies to term, really fits into a particular pernicious agenda. And I think it's important for us to recognize that that's a piece of what's going on here as well. The idea of the wrong people having babies is very American.
I was actually wondering, Dean Mutcherson, if you could hit the ball that Professor Ziegler teed up there about people being prosecuted for particularly people of color being prosecuted already.
Yeah, so there's a particular history. There was a case that went up, probably one of the more famous cases that went up to the Supreme Court, which was a case against the Medical University of South Carolina, because they had a program in which basically when women showed up for prenatal care, they would test people to see if they were taking illicit drugs, and just illicit drugs, right? So if you had a prescription for what you were taking, they weren't going to worry about that. And this was a public hospital. It was a hospital that mostly was providing reproductive health services to poor women and to women of color. And they created a program with the local police and the local prosecutor's office, where if a woman came in and tested positive, they would try to send her to rehab, of course, recognizing that most rehabs don't want to take you if you're pregnant. And so then if you tested positive again, or if your baby tested positive at the point where you gave birth, they would arrest you, right? So, I mean, we're talking about women who are in labor, who are being shackled to their beds, and then who are being separated from their babies right after birth. the idea that the proper response to concerns about a woman who has substance use disorder and is pregnant is prison is pretty wild, right? I mean, that is a public health problem. That is not a criminal law problem. So that's something that we've seen already. And so there is already an appetite for punishing particular women, poor women, women of color, and all the women, I should say, who were involved in the Ferguson case in South Carolina. All of them were Black, except for one woman who was white. And the nurse who was in charge of the program, a woman named Shirley Brown, wrote in that woman's chart that her boyfriend was Negro. So there's a very deep class and race line that runs through all of this that will continue to be problematic in a world where Roe doesn't exist anymore.
So there are a bunch of really great questions already in the Q&A. And so I'm going to combine two and then tack on. One of them is sort of asking about how basically can we stop Roe v. Wade from being overturned? How are organizations trying to fight this? And this person says right now these efforts seem sort of weak and invisible, and to roll another question into it, if at this point there's kind of nothing really that can be done at the court level of stopping Roe from being overturned, there's another question that says, you know, how quickly is this going to happen? What states, this person knows about trigger laws. And so how many states have trigger laws where this is going to happen automatically versus how many states are going to be passing legislation? Like, how fast is this going to happen?
Well, I'll tackle the first one. Does that sound good, Mary? And then you'll tackle the second one. The thing to recognize about the U.S. Supreme Court is that they don't answer to us, right? Once you are on the court, you sit on the court for life, and you are appointed to the court, or you're nominated for the court by whoever is the sitting president, and then you are confirmed by the Senate. So once you're there, you're there. And the idea that you could sort of, you know, lobby justices on the Supreme Court to make whatever you think is the right decision is just sort of not how the system works. So, you know, the only people who really have an impact now are those folks who get to go in front of the judges and who get to argue the case. And that's already been done in Dobbs. And so we're just waiting for the opinion. So there isn't that much for advocates to do, right? Because the way that you change the kinds of decisions that the Supreme Court makes is you change the people who sit on the Supreme Court. And that's a political issue that we should all be thinking about the next time we have to vote for a president, because courts matter. So that's one thing. The second thing that I'll say, though, in terms of thinking about our judicial system, is that the Supreme Court isn't the end all be all, right? States have state constitutions as well. Some of those constitutions are substantially more expansive than the US Constitution. So for instance, you know, the word privacy does not exist in the US Constitution, but there are state constitutions that very specifically lay that out. And so some of what we might see is advocates shifting from federal courts to state courts that will potentially be more protective of a right to access abortion. And if that happens, it's possible that in some of those states that otherwise would want to criminalize or to make abortion illegal, that there might be some refuge in state Supreme Courts and state courts. I wouldn't count on that too much, but to the extent that courts are still in the game, it's probably state courts, not federal courts.
Yeah, I mean, I agree with that. I think on the courts point, as a historian, I would just emphasize that everyone, I mean, the reason the anti-abortion movement has been so successful is that when it comes to the courts, they've been playing the long game. And so I think that it would behoove people who are supporters of reproductive justice to view courts in the same way. So if you're interested in courts and advocacy in courts and sort of constitutional protections for reproductive justice, like, you should care about that, but recognize that that is not going to be like a tomorrow thing. That's going to be a sort of changing who sits on the court, changing how we approach the Constitution. And just as that was the case for the anti-abortion movement, that's going to take some time. In terms of how quickly bans are going to kick in, a lot of them are going to be quite quick, right? So, I mean, it's somewhere between 20 and 25 states that either have trigger laws, which are bans that are set to take effect as soon as Roe is overturned. Other states like Wisconsin, for example, have retained pre-Roe criminal bans, which would also then go back into effect were Roe to be overturned. And then there are other states that have Republican governors and legislatures that would be, you know, possibilities for additional bans on abortion. But there, I think there's actually advocacy work to be done, right? So just to take an example close to home, Florida lawmakers just introduced a ban on abortion at 15 weeks. Now, why is that interesting? It's interesting because Florida legislators recently had introduced a ban on abortion at 6 weeks, and then spent the better part of like 4 months assiduously avoiding discussing this ban because they weren't sure that voters in Florida were going to go for it. Because while Florida is a red state, it's not that red a state. And so there was a question of sort of how much appeasing the anti-abortion base should Republicans be doing versus making a bunch of other people in Florida really mad. And so there are going to be a subset of states where what abortion law looks like is not at all going to be clear. Now, some of those states are off the table because of pre-Roe bans, like Wisconsin should be a battleground, but probably won't be because of that. There are other states that could be battlegrounds, but are going to be off the table because of state Supreme Courts and state constitutions like Iowa. And then there are going to be just pure battlegrounds where I can't in good faith tell you what the law is going to look like. So I think some of this will happen quite quickly, but I think it's also worth saying that it's not forever, right? I mean, if your state has a trigger law that goes into effect, you can advocate against it and try to get it repealed. And another thing that I think obviously is very important to pay attention to is state elections, period, right? I mean, I think in addition to being very good at playing the long game when it comes to the courts, the anti-abortion movement has been very good at influencing state legislative elections, state court elections, state court nominations. And if a lot of the action is going to be in the states, there's actually a lot that's, I think, remains to be seen on that front that will be up in the air after Roe is overturned, probably for some time.
And let me just add, if you care about abortion rights, then you care about voting rights, right? Because a huge part of what is happening here is keeping certain populations and certain people from having access to the vote, which then affects who gets to sit in your state legislature. And that then affects the kinds of laws that are being passed in your jurisdiction. So those two things are not separate. And they are also part of a concerted and long-term effort to consolidate power.
It's the same people too. I mean, historically, like I started out as a historian of the abortion debate, and like my new book is mostly about, you know, campaign finance and voting laws. And the thing I'm working on now is pretty much entirely about voting laws. And I'm not studying different people. It's just the same people doing the stuff that Dean Mutcherson is describing too. So like it's not even, there's no, you know, daylight. It's often the same cast of characters.
This conversation leads so beautifully into one of these questions that I'm just going to read the question. Will there be a political reaction in the post-Roe world in which it is overturned? It's the case that I think it's supposed to say, is it the case that the entire South and entire Midwest will accept these changes, or will there be a backlash? Some of these states, depending upon who you believe, voted for Biden, and there may be statewide support for pro-choice policies in these areas.
Yeah, I mean, backlash is really complicated to predict, right? So on the one hand, we have really clear, really consistent polling suggesting that Americans don't want Roe to be overturned. They don't like bans early in pregnancy. They don't like the idea of criminalizing anyone, right? So that's really clear. So on the national level, you would think there would be a backlash. The reason that there are caveats is because, one, our political attention is so divided, right? I mean, people are preoccupied about COVID and inflation and a million other things. So the extent to which there's a backlash will really be up to people like you, right? To what extent this issue is like the issue you care about, like something like this in voting rights. Is this what you get up and think about? Or is this just sort of like something, because generally, historically, there's been a tendency for progressives to say, oh yeah, I care about abortion rights. But then when it comes to voting, they're kind of like, meh, you know, it's like number 7 or 8 on the list. The other thing that makes it complicated is just the depth of political polarization in this country, right? So I think what the bet that lawmakers in the South and Midwest are making is that there's enough negative and effective partisanship. That is to say, there's enough antipathy toward Democrats in those regions and enough uncompetitive races that even if people in those states don't like the abortion policies that are being introduced, and we have polling in many of these states to suggest that people would not, that majorities would not, that won't really matter because people would never vote for a Democrat anyway. And I think that's really hard to predict too, because we have lots of evidence to think a backlash would manifest. And when we've seen previous backlashes, it's been in a much less polarized America with much less negative partisanship. So I expect there to be a backlash. I expect there to be a clearer national backlash. Regionally, I think it's harder to predict. And I think it's just harder to predict, period, because unfortunately our partisan divide is so much worse than it was even say in the 90s when Casey came down, that I think it will remain to be seen. But I think another important point to make is that, I mean, you if you're listening to this, you can help determine the scope of the backlash. It's not, there's nothing preordained about how big it is or what it looks like. It'll have to do with how much people care about this when the moment comes, and to what extent they actually feel they have skin in the game and actually make this a priority when they vote or when they go out to protest.
There are a bunch of sort of legally oriented questions that have come up, and I think I want to kind of combine two of them, right, at least for the time being. Basically, these are getting at what sorts of, if we're going to ultimately sort of like play the long game, right, and be working sort of at the legal level. There's lots of things to do for changing the bench, but different types of arguments to bring. One question came in about how is the anti-vax movement impacting reproductive rights, because some on the anti-vax side are arguing basically a no one can tell me what to do with my body argument, right? Which would seem to have clear implications for this conversation. There's also another question that's asking about, well, are there opportunities to make arguments through the Equal Protection Clause of the 14th Amendment? So sort of one staying sort of with the privacy, but capitalizing on another line of reasoning or another context really, and then the other saying, well, there are other argumentative options. What are your thoughts on the viability of those, so to speak?
Well, I would love to take the public health one, because the other work that I do is in health law and public health. So first of all, the issue that we're talking about within the context of vaccines is a public health question, right? It's a question about not what you do with your body, but the ways in which your choices impact the public and impact other people. So it is simply not the case that we live in a country that says you can do whatever you want, however you want to do it, no matter what impact it has on other people. And we have long had a constitutional tradition in this country that says that the state, that the government has some level of power as a sovereign to protect the public's health. And a lot of that has been done through vaccination programs, which have been mandatory for centuries, right? This is not some wacky new thing that we have suddenly started. And so in that way, the anti-vax conversation is within a completely different bucket, I would say, than what we are talking about here, which is about individual choices about what happens inside your body versus the ways in which your individual choices impact a much larger range of people. And Mary, do you want to take the equal protection question?
Sure. Yeah. I mean, and I'll add quickly on the so historically, right, the anti-vax movement has some antecedents. So there's interest, like my second book, I was basically noticing how a lot of people on the right used Roe in the 70s. And they used Roe often to mean access to unproven, unsafe medical care. So there was sort of this was under the surface for a while. And in the anti-vax movement has kind of burst forward in a really pronounced and obvious way. But there's a kind of tradition in this country of people arguing that they have a right to ignore public health authorities and access unsafe treatments. And they've, I think, sort of twisted what we mean by privacy or autonomy in claiming that right. And of course, that's been amplified by other changes in recent years, like the fact that people are getting their information, whether it's from kind of siloed media that don't whether it's the fact that they don't trust the same experts or the same data, or that they're relying on social media, or that they just don't have people in their community with whom they disagree. Interestingly, people in the anti-abortion movement make the my body, my choice argument in an anti-vax context. So the attorney who's leading the litigation against Indiana University's vaccine mandate is the general counsel for the National Right to Life Committee, which is one of the largest national anti-abortion groups. And the architect of the heartbeat bills, Janet Folger Porter, is leading a sort of campaign against President Biden's vaccine mandate. So I think, interestingly, it's not just people who are pro-reproductive justice who think that vaccine mandates are in a different universe than the right to choose abortion. Anti-abortion folks seem to think that too, for whatever it's worth. Equal protection arguments, I think, have long been seen as more promising, partially because they're more textually grounded, right? I mean, part of the criticism, of course, of the holding in Roe is that there's no right to privacy in the US Constitution, as Dean Mutcherson mentioned. And of course, there is a right, equal protection is in the 14th Amendment unambiguously. There's some historical evidence that the framers of the 14th Amendment were particularly concerned about forced pregnancy and slavery, and would have been particularly mindful of that when thinking about what equality means, because that was one of course, the great evils of slavery, that people had, in addition to not control of their lives and their humanity, didn't have control of their pregnancies and their bodies. So I think, obviously, in the short term, I don't think that's a promising argument. I don't think the US Supreme Court is going to care about any of those arguments. But I do think that if Roe is gone, and we're thinking about this in terms of the long game, really what we're talking about is kind of reimagining abortion rights for a generation down the road. And it's quite likely that equal protection is going to be the framework that's used for that, for some of those reasons. Again, I think also with an eye to the fact that there are intersecting equality concerns at play here, because if you look at who actually has abortions, it's disproportionately low-income people of color who are, I'm assuming, sometimes want to have abortions for reasons that are understandable, but sometimes they're also having abortions because their lives are not what they would like, because of structural racism, because of poverty, and so on. And of course, that raises concerns about equality, not just on the basis of sex, taking trans people out of it, but on the basis of race and class as well. And I think equal protection arguments can kind of bring all of that in a way that autonomy arguments don't naturally. The one thing I will say, autonomy arguments are less weak than you would think, because if the Supreme Court is seriously going to say there's no right to choose abortion because privacy arguments are trash, they're going to then have to explain how privacy arguments are not trash when it comes to the right to parent, the right to marry, the right to use birth control, and the entire structure of substantive due process, we call it, that really is grounded mostly on autonomy concerns, with some equal protection sprinkled in. So as much as I think it would be good to have a kind of better framework for abortion rights, I think some of the criticisms of privacy rights arguments are a little overstated, because they don't really explain the differences between rights everyone takes for granted and is not seriously thinking of revisiting, and ones that they think are much more vulnerable.
That actually segues perfectly into another one of these questions, which basically is asking, a lot of US law turns on this conceptual notion of a right to privacy, and where do we expect those reverberations in privacy law to reverberate to should Roe v. Wade be overturned, and where are we not expecting, I'm adding that, but where are we not expecting them to reverberate, and why?
So the first thing I think is going to be contraception. And the reason I think that is that so I was going to write a book about how there's always been a war about birth control, but then I had to stop, because now I'm gonna have to write the how Roe v. Wade got overruled history, because that's on the shelf. But the how birth control got contested book is there because there's always been a fight about what birth control is, even when there was a superficial consensus about it being relatively okay compared to other culture war issues. So the first thing that's going to come up is, when states ban abortion, can they also regulate or ban infertility treatment? Can they also regulate or ban IUDs? Can they also, and that we already see that coming, because there were fights about that during the contraceptive mandate, right? When a lot of those treatments were viewed as abortion inducing drugs. So that could happen without the Supreme Court saying anything about anything else privacy related. Just once they say you can ban abortion, then the states are going to have to figure out what abortion is. And we're going to have to fight about whether their definitions of abortion interfere with rights to contraception or not. After that, it's harder for me to say, right? And I think the question really there becomes, how much appetite does this conservative supermajority have for political backlash? On the one hand, obviously, it would be very different for the court to say, oh, by the way, you know, there's no right to same-sex marriage either, and there's no right for married people to use birth control, and there's no right to, you know, shape the religious upbringing of your child. Like, the degree of backlash, there's going to be, I think, a backlash to overruling Roe, but if you can imagine, like, that would be like, multiply that by like 1,000, right? On the other hand, this Supreme Court's willingness to overrule Roe and do it this quickly, instantaneously upon the court's membership changing, suggests to me that this court may just not really care about backlash. Like, that's kind of my reading of it. The big constraint on the court historically, Dean Mutcherson mentioned, right, the court isn't accountable democratically, right? They're nominated for life. They don't get, you know, impeached very often or withdrawn very often. And so historically, when the court has kept hewed relatively close to popular opinion, it's because there's been a fear of backlash, right? And because historically, when the court has broken with popular opinion really aggressively, it's often been disastrous for the court. It's often resulted in things like pushes for court packing and so on. But if this court is basically saying, we're going to just roll the dice and we don't care about backlash anymore, that doesn't necessarily mean they wouldn't try to say there's no right to, for example, same-sex marriage or contraception. I would not put that out of the question. I'm expecting when the court overrules Roe, they're going to say they're not going to do stuff. Like, I think we're probably going to get Brett Kavanaugh writing, and he's already kind of telegraphing. He's been like, we're not saying the Constitution is pro-life, guys. And like, you know, same-sex marriage, that was like a great opinion. Like, he's going to probably try to say this is just about Roe. But I think a lot of people are going to not believe him, and probably with reason.
And I also think that we want to be, you know, again, another area that I work in is assisted reproduction, right? And so, you know, Mary was making the point about what does it mean in a world where we are no longer taking the position that a fetus is, you know, not a constitutional person, right? And so we start getting states who, you know, their attempts to pass personhood amendments were not very successful, but in a post-Roe world, will they become more so? And if they do, you know, what does that look like? So when an embryo is a person, what happens when a fertility practice accidentally destroys 50 embryos? Is that a criminal prosecution? Is it a murder prosecution? Who's responsible for that, right? And so it really sort of, you know, how comfortable are we with punishing pregnant women in particular, but pregnant people in general, for behavior during their pregnancy, right? It's what you might find a whole category of people who say, all right, if you're taking, you know, meth during your pregnancy, or, you know, taking cocaine during your pregnancy, that's a bad thing. We don't want to see people doing that. But they might get a little more uncomfortable if we're starting to prosecute you because you're over exercising, right? Or if we're telling you that you can't, you know, do your job anymore because it creates too much of a risk to a fetus, to that person who is gestating inside of your body. All of a sudden, I think that lots of people would get much more uncomfortable with what we're doing here, because once you start breaking down some of these conceptual lines, what's possible, it's very expansive very quickly.
Yeah, and I mean, I think it's also worth saying this on the table, right? I mean, I was talking to a pro-life activist from Texas, and this is worth saying, this is like the sort of moderate pro-life group in Texas. And he was saying, oh yeah, like fertility clinics are 100% on the table. It's like, there shouldn't be as many of them. We're hoping to close some of them down. So, I mean, my sense in studying this is what I'm hearing, like, I think we have no idea how far this is going to go. I think as someone who studied this and talked to these people for a while, I think like my sense of how far it was going to go was like, I feel naive, right? So I think it's going to cover a lot more areas than we're thinking of at the moment.
And let me just add one more thing to scare people. There are thousands upon thousands of frozen embryos in the United States right now. If those are people, then, you know, parents deciding we want to donate to research, parents deciding we want to destroy them because we're not going to make any more babies with those embryos. You know, what happens when a state says, actually, we're going to give them away to other people who want to have babies, because you don't have a right to make a decision to destroy that life. So we're going to allow other people to use them in order to try to become pregnant. We're going to allow them to adopt them, even if that's not what you want as the people who are the genetic progenitors of those embryos, right? I mean, that's all of this stuff ends up on the table when we start having these conversations and really moving the line in significant ways.
you're making me really want to talk about The Handmaid's Tale, but I will go to the questions instead. There are a few questions that are kind of getting at this. Well, one is kind of encapsulating a lot. You said pro-life interests have been playing the long game to get to where we are today. Is it true then that the pro-choice group has not been playing the long game? And if so, how or why did they miss this opportunity or miss this strategy? And that kind of gets to, there was another question that sort of seemed to feel like this seems to be happening so quickly. Why are we moving so quickly away from what the abortion movement was able to accomplish in the 1970s?
I think you should start, Mary, because you've got the nice sort of historical perspective there. But I have an intersectionality analysis that I want to do too. So I'll wait until you're done, though.
Yeah, I mean, there's so many, it's really complicated. I mean, so I think progressives haven't paid a lot of attention to the courts. And when they have, they've assumed that the rules haven't changed, right? So I think there's an era in which everybody is playing the same game with the courts, right? Where you nominate like this sort of Sandra Day O'Connor type of person, where everybody is going to say yes, and they're going to get unanimously confirmed. And everyone's going to say, oh, great, this person is sort of a centrist. And both parties are doing that for a while. And then there's a point when the anti-abortion movement is influencing things, when Supreme Court nominations on the right, through the anti-abortion movement, through the Federalist Society and so on, become a way to turn out voters. There's the era of kind of consensus sort of cipher picks is gone, right? And you can find different moments where that era begins to fade away, like Robert Bork's failed confirmation in '87, Harriet Miers getting deep sixed in 2005. But now we're in a world where I think progressives were still nominating the same kind of like Merrick Garland style centrist folks that everyone was supposed to like, and assuming that everyone was going to play fair. And on the right, there was sort of asymmetric hardball, right? Where we hold up nominations, we're going to put up people who are exciting to the base, regardless of whether they're the sort of standard model for someone we would nominate to the Supreme Court. And I think that it's really just recently that progressives are realizing that that's what's happened. So the court has been transformed in ways because I think what conservatives view the court as being has changed, right? I think in part that's also because over time, particularly the anti-abortion movement, but other conservatives too, were recognizing that goals that they had would be achievable only through the Supreme Court, right? So what the anti-abortion movement is seeking, of course, is not to overrule Roe, it's to ban abortion nationwide. The anti-abortion movement views itself as a human rights movement. And if you view yourself as a human rights movement, you're not cool with it if people are violating human rights in like California or New Jersey or New Hampshire, like you want to have a nationwide abortion ban. Is that ever going to happen through popular politics? Like, no, right? That's not going to happen through popular politics. There's not going to be, I don't think, a nationwide statute banning abortion. There's not going to be a constitutional amendment banning abortion. But could there be a Supreme Court decision recognizing the personhood of a fetus under the 14th Amendment? Yeah, totally. With this Supreme Court, I wouldn't be that surprised by that. So I think there also came a point when what the Supreme Court was supposed to be to the anti-abortion movement and conservatives changed as well. And the kind of promise of creating a truly counter-majoritarian anti-democratic Supreme Court, which had not really been how the Supreme Court functioned, became kind of a quest, I think, in a way that hadn't been the case. And then I imagine what Dean Mutcherson is going to say, which is also true, I think, is that the way progressives were playing the game also ignored the people who were the most affected by regulations of abortion in ways that I think both hobbled the movement, kept its membership, I think, weaker, smaller, less energized, and also kind of opened the movement to arguments that the other side was making, right? I mean, you hear anti-abortion folks saying, abortion is racist, right? The abortion rights movement, there's like a direct through line from eugenics to population control to the modern abortion rights movement. And if you want evidence, look at how they're treating people of color. Look at how they don't really care about the Hyde Amendment. Look at how they don't really care about other issues of social justice. Look at how they don't really care about voting rights in states in the South. That argument becomes a lot more credible when the abortion rights movement had largely been saying, well, donors don't care about the Hyde Amendment, right? They don't, doesn't affect them. So we're not going to emphasize it because it doesn't raise us any money. The median white male voter who isn't cool with state interference, he doesn't care about the Hyde Amendment. So we're not going to stress it. The sort of moderate Democratic senator, like the sort of Joe Biden of 25 years ago, doesn't care about the Hyde Amendment, so we're not going to stress it. So there was, I think, a willingness to, and it's pretty clear and depressing in the archival record, to ignore concerns of people of color that I think is also biting progressives now, in addition to this kind of blindness to the changes to what the Supreme Court has been intended to be, that I think are also hurting.
Absolutely. And I think that it's so critical. I mean, even as we look at, mainstream reproductive rights organizations, and I'm going to call them reproductive rights organizations, not reproductive justice organizations. If we look at those organizations, they tend to be run by white women, by middle-class women. And it has been an enormous fight to get a lot of those organizations to really look much more expansively about who are the people who you are working for, and what are the rights that you should be working towards, right? And it's sort of exemplified by a range of different sort of conflicts within the movement. So think about white women in mainstream reproductive rights movements who were screaming about, their gynecologists who wouldn't let them get, sterilized when they were in their 20s and 30s and knew that they didn't want to have babies, and how outrageous, and how could you treat us like this and not let us, make these decisions. And Black women in the South are saying, I went in to get, my appendix out and they sterilized me and I didn't even know about it, right? I mean, the incredibly different experiences that folks are having in this country, and the sort of mainstream organizations that took far, far, far too long to start paying attention, and far, far, far too long to start thinking about how to organize, not just among their peers, but to listen to people who are on the ground in Black communities and poor communities and Latinx communities in the South and in the Midwest, listening to those folks who were sounding an alarm because they saw what was coming down the pike. And what was coming down the pike wasn't just people who were talking about abortion. It was the people who were talking about voting rights, and there was the people who were talking about the social safety net. All of those things were a precursor to where we are now. And it took far too long for the folks who were in charge to say, maybe we're missing something, right? Maybe there are voices that we should be hearing that we aren't hearing. And now, this is where we find ourselves.
Yeah, and the only thing I'll add is sometimes it's really good for social movements to lose in the Supreme Court. I think that there's been a kind of false sense of like we've got the Supreme Court, like we've got the right to choose abortion. There's like tons. I mean, if you're a historian and you're reading archival material, it's kind of like the horror movies where people are like going down the stairs and they're like, oh, look, there's chainsaws down there. Like, it's going to be great, guys. Let's go. It's like that where people are like, oh, the Supreme Court, like we've got it. It's all good. Literally, they'll say things like, the Supreme Court has spoken and this is over. And you're like, no, we're going to be talking about this 50 years later. It's not over. And so I think in a way, I'm beginning to see that shoe on the other foot. So you now begin to see anti-abortion people saying it's like the Supreme Court is like Santa when you're 5, where like they're going to give you everything you want and politics are going to cease to matter. And it's going to just be like, amazing. You're going to get everything you want in your stocking in the morning. And so I think it's good in a way for progressives to take this sort of, complete 180 by the Supreme Court that's going to probably get rid of abortion rights and a lot of other stuff, both to remember that courts matter, but that courts are part of a much more complicated kind of interlocking picture involving things like politics, social movement organizing, and the like. And also to take advantage of the fact that I think that conservatives are beginning to fall into that same trap of thinking that the Supreme Court somehow acts in a vacuum and can deliver you everything you want, notwithstanding the fact that people in the public don't seem to want what you're asking for.
We have about 5 minutes left, and there's a question that came in. And by the way, I'm going to take away that image of the Supreme Court as Santa. That will live with me for a long time to come. But there's a question that came in that I think is really, really interesting. It's sort of as a wrap up. I think that when we talk about the question of abortion today, we all just sort of assume and walk into it in the United States, just assuming, oh, it's this super controversial thing. And well, it is so for obvious reasons. But the question came in, can you talk about the longer history of abortion and perhaps like when did abortion become a controversial topic? Was that always true? Was it true in the common law? Or is that a more recent development?
It's definitely more recent, and it's also interesting to look at it internationally. So What the anti-abortion movement argues is basically that it was Roe, right? That what happened is that the court imposed this on us and that it wasn't like a sort of grassroots bottom up kind of change. So at common law, people obviously in the United States, just as in every other country, have always had abortions. We know that Native peoples had abortions, enslaved people had abortions, people who were in colonial settlements who were white had abortions. Like there was nothing remarkable about that. They didn't tend to be criminally punished. Most of the time when you see it showing up in criminal records, it's because they were being prosecuted for fornicating and then happened to get pregnant, and the abortion got thrown in there too. To the extent when laws began to be more formally passed covering abortion, they tended to either deal with abortifacient drugs as poisons, because they often were, or they tended to punish abortion either only after quickening, which was the point at which fetal movement could be detected, only after quickening full stop, or only make it a serious crime like a felony after quickening. And so that began in the 19th century, and it wasn't really until the late 19th century that abortion was fully criminalized in most states early in pregnancy. And when it was not only because so-called regular physicians believed that life began at fertilization rather than at quickening. It was also because those doctors were worried that white women were not having enough babies, and that immigrant women and people of color were having too many babies, and because they were worried that abortion was allowing women to no longer play their kind of natural role as mothers and wives. So abortion, and I mean, I think even then you wouldn't really say abortion was controversial, because after those laws passed, people just kept having abortions, and then generally nobody went to jail for it unless the actual patient was killed. So to get to the point where you have a sort of modern abortion debate in the United States, I think a lot of things change. One of the most significant is that abortion is a fundraising issue in the United States. It's a political party issue in the United States in ways that are not true in most parts of the world. And where it is true in other parts of the world, like Brazil, where there's a kind of conservative party that has an anti-abortion movement as a base of support financially and in terms of the vote, you see very similar kind of culture war struggles. So there's a lot of people with a vested interest financially and politically in fueling our abortion wars. But there's nothing, I think, preordained about our religious composition that makes abortion as divisive as it is. There's nothing preordained about abortion being divisive as it is because the Supreme Court got involved, because our party divides about abortion didn't take shape until the 80s, really. I mean, in the aftermath of Roe, there was no partisan divide on abortion. So, I mean, that's both depressing because we're sort of unusual or unique in how divided we are about abortion, but it's also hopeful because in lots of parts of the world, they've found ways to get through their own abortion divides and get to the other side of them and get to a saner conversation. And I think there'd be ways for us to do that too, even though I think there's an entire sort of outrage industry that profits from the way we do business now.
I also think there's it's interesting to think about how technology plays into, some of the ways that we think about pregnancy. If you've known anybody who's, been pregnant, happily pregnant, right, and carries through pregnancy to term, we all put those ultrasound pictures up on our refrigerator, right? I mean, that sort of sense of being able to picture a fetus and really start to think about a fetus as a child very, very early in pregnancy, and physicians who are willing to say things, true or not, about, when a fetus feels pain, when a fetus, opens its eyes and looks at its mother, the fact that we can, physicians can do fetal surgery now, right? I mean, it's sort of extraordinary what kinds of things can happen. And I think that also sort of changes the culture in how people think about pregnancy, because we can watch it and we can see it in a really different way than we used to be able to.
Thank you so much. I mean, we have 1 minute, and I, on the one hand, would love to take advantage of that. On the other hand, I know that any way that I took advantage of it would shoot us well over. But I really want to thank you. This has been a fascinating, albeit somewhat disheartening. Actually, maybe, no, that's how I'm going to end it. Like, both of you, say something heartening.
Honestly, I think we live in an amazing time, right? I mean, I think we live in a time where the opportunities for organizing, the opportunities for thinking about how to work across difference are tremendous, right? So the upside here is I think that there are a lot of people who are experiencing disruption, right? People who thought, this is a thing that just will stay here forever and you don't have to think about it, and who suddenly have to really sort of re-envision who we are in this country and what it takes to be the country that we want to be. And I don't think that's a bad thing.
Yeah, and I think it's also a good time to remember, one of the things I'm not going to be surprised by is if the Supreme Court overrules Roe, I don't even expect Roe to go away. Because one of the things that strikes me is even when we talk about Roe today, we're not talking about what the Supreme Court said. We're talking about the idea of a right to abortion. We're talking about broader concepts of reproductive justice. So even when it comes to what we think of when we think of the Constitution and abortion, or frankly, what the Supreme Court says, we're contributing to that. We're reshaping that. And so I think it's also an important moment to remember that whatever the Supreme Court says, even if it claims that it has the final word, we know historically that that has never been true and will never be true. And so that's certainly going to be true when it comes to political opportunities and access to things like abortion, but it's also really frankly going to be true when it comes to the Constitution too. So it's worth remembering that historically that the Supreme Court, the last time the Supreme Court thought that it had the final word, Harry Blackmun had like a little clipping in his file of a poll that said that more than 2/3 of Americans think abortion should be a decision between a woman and her doctor. And he made a little note. It was like, we're gonna just resolve this. And people who think that they can resolve this or stop people from caring about this are fools, right? And we know that. And so it's good to remember that when you think of what you yourself can do.
Well, thank you so much. That's actually a great way to end, regardless of any particular position, that we have power. We have autonomy, and it's not the Supreme Court in some senses has a final word, but they don't have the final word. So this is always abrupt and weird ending a webinar, but thank you all so much. And thank you for organizing Dartmouth Women in Law and Politics and the Rockefeller Center. And yeah, have a good night.